All of us who have insurance policies, whether those are homeowners policies, health insurance policies, or automobile policies, make policy premiums to our insurance company. And when we do, we expect that if we have to make a claim on that policy, that the insurance company will live up to its responsibilities. Oftentimes it doesn't. California law has created what's called a duty on that insurance company of good faith and fair dealing. And that basically says that the insurance company has to put your rights and your interests at least equal to and possibly above its own financial interests. And if they haven't done that, you might have legal rights against that insurance company, and you need to seek consult with a lawyer to evaluate that. What we oftentimes see is when claims are made, insurance companies will either delay investigation, try to trump up reasons to deny a claim, or even rescind the policy completely in order to avoid what may be considered to be significant future payments on that policy. If that's the case, they are obligated, or they're potentially exposed to, damages in a civil lawsuit. Those can be the contractual damages that they would otherwise have to pay if they acted reasonably under the policy, but they might also include additional things like emotional distress damages or extra contractual damages, where you might even be able to recover, and the insurance company might be liable for damages in excess of what the policy would have otherwise provided. And the situations where we're consulted with oftentimes by people who have been wrongly denied or had their policies rescinded by insurance companies might be health insurance situations where, as we've all seen in the news, someone might be diagnosed with cancer or other serious health condition. Their doctor recommends a certain treatment, and the insurance company looks for a reason to consider that to be either not a medically accepted practice or procedure or some other reason to deny it. And that's a life-threatening situation that needs immediate legal recourse. Those are situations we see. And other situations we'll see is where people might have been injured in an automobile accident, and the responsible driver might have a small insurance policy that's inadequate to compensate them for their loss. And once that policy is paid by the responsible driver's insurance company, then we'll turn around on behalf of our client and bring an action against their own insurance company under what's called their uninsured or underinsured motorist coverage. And that provides that exact type of protection. If the person who injures you doesn't have enough insurance, that's what you've paid that premium for, is that safety net. And again, oftentimes those insurance companies, even though they have what's called a first-party obligation to you, that contractual right and that contractual obligation, will look for reasons not to pay the damages that you've suffered. And that's where a lawyer will be involved, and we're very experienced in these cases where we'll actually bring the action and arbitrate a case against your own insurance company. And if the arbitrator hands down a ruling in your favor, even if it's above and beyond the policy limit that you would have otherwise been entitled to, we can either get that additional extra contractual damage from the insurance company that they otherwise wouldn't have been obligated to pay if they'd acted reasonably, or even bring a bad faith lawsuit and seek those emotional distress or extra contractual damages. Again, it's a very complicated area of law. If you feel that your insurance company hasn't treated you fairly, you need to consult with a lawyer. And those of us at Thon, Beck, Vanni, Callahan, and Powell are very experienced in these cases, and we'd be happy to consult with you and evaluate your case. Thank you.